Question 381. When a real estate agent acts exclusively as a buyer's agent, he can do all of the following except: A. Present offers directly to the seller. B. Present offers to the seller and seller's agent. C. Withhold confidential information about the buyer from the seller. D. Act as an exclusive agent of the seller. Correct answer is D. Act as an exclusive agent of the seller. When a real estate agent establishes an exclusive buyer's agency relationship, their allegiance and legal responsibilities are unequivocally directed towards representing the buyer's best interests throughout the entire real estate transaction. This fiduciary duty mandates that the buyer's agent act with utmost loyalty, confidentiality, and diligence on behalf of their client. Their primary goal is to assist the buyer in finding a suitable property at the most favorable terms and price possible. To effectively advocate for their buyer, the agent will engage in activities such as researching available properties, arranging property viewings, providing objective advice and guidance, and strategically negotiating offers. In fulfilling these responsibilities, an exclusive buyer's agent is fully authorized to communicate directly with the seller or the seller's agent to present their client's offer to purchase. This direct communication is a fundamental aspect of the negotiation process, allowing the buyer's agent to advocate for their client's terms and conditions. Furthermore, the duty of confidentiality inherent in the buyer's agency relationship requires the agent to safeguard any sensitive information about their buyer from the seller. Disclosing confidential details, such as the buyer's absolute maximum price or urgent need to purchase, could potentially weaken the buyer's negotiating position and would be a breach of the agent's fiduciary duty. However, the core principle of exclusive buyer agency inherently prohibits the agent from simultaneously acting as an exclusive agent for the seller in the same transaction. Representing both the buyer and the seller as an exclusive agent would create an irreconcilable conflict of interest, as the interests of the two parties are typically adverse. The seller aims to achieve the highest possible sale price and favorable terms, while the buyer seeks the lowest possible price and advantageous conditions. An agent cannot ethically and effectively represent these opposing interests exclusively at the same time. Therefore, an agent acting solely as a buyer's representative cannot also serve as the exclusive agent of the seller in that specific transaction. Question 382. Which of the following actions by a broker would violate the rules regarding trust funds? A. Cashing a deposit check after acceptance of an offer at the seller's direction. B. Keeping a deposit check uncashed after acceptance of an offer at the seller's direction. C. Keeping a deposit check uncashed by their own decision. D. Keeping a deposit check uncashed before acceptance of an offer at the direction of the buyer. Correct answer is C. Keeping a deposit check uncashed by their own decision. Real estate brokers in California are held to strict standards regarding the handling of trust funds, which include earnest money deposits provided by buyers. These funds belong to the buyer until the offer is accepted, at which point they are typically held in trust for the benefit of both parties according to the terms of the purchase agreement. Brokers have a fiduciary responsibility to manage these funds with utmost care and in compliance with real estate law to protect the interests of all parties involved in the transaction. Violations of trust fund rules can occur when a broker fails to handle deposit checks appropriately. Cashing a check after offer acceptance at the seller's direction or holding an uncashed check before acceptance with the buyer's written instruction are usually acceptable. However, a broker deciding to keep a deposit check uncashed without a valid reason or instruction is considered a problematic practice. This lack of action can raise questions about the broker's handling of client funds. This unilateral action can be viewed as a failure to properly manage trust funds and could potentially lead to commingling issues or delays in the transaction process, thus violating the broker's fiduciary duties and the regulations governing trust fund handling. Question 383. Among the following factors, the most significant one affecting home value is: A. Quality of workmanship. B. Buyer demand. C. Square footage. D. Ratings for nearby schools. Correct answer is B. Buyer demand. While several factors influence home value, buyer demand is often considered the most significant and dynamic. High buyer demand in an area creates competition, driving prices up, even if the homes themselves have varying qualities. Conversely, low demand can lead to price reductions regardless of a home's features or condition. While factors like the quality of workmanship, square footage, and ratings for nearby schools are undoubtedly important and contribute to a home's desirability, they are all evaluated within the context of the prevailing market demand. A well-built, spacious home in a good school district will command a higher price when many buyers are actively seeking properties in that area. However, even these desirable features won't necessarily maintain high value if overall buyer interest in the location or type of property wanes. Question 384. The recording of a lease will generally be performed by the A. Lessor, B. Lessee, C. County assessor, D. Life estate holder. Correct answer is B. Lessee. Recording a lease provides constructive notice to third parties, like potential buyers or other lien holders, of the tenant's rights to occupy the property under the lease agreement. This protects the lessee's interest in the property. Since the recording primarily benefits the lessee by securing their tenancy against subsequent claims or sales, they are the party most likely to initiate and pay for the recording. While the lessor is a party to the lease, they don't typically benefit directly from recording the lease. In fact, a recorded lease might encumber their ability to sell the property freely. The county assessor's office is responsible for determining property values for taxation purposes. They record documents related to ownership and transfers of property but are not typically involved in recording leases. A life estate holder has the right to possess and use the property for the duration of their lifetime. They are not typically involved in the recording of leases unless they are acting as the lessor for a lease that extends beyond their life estate, which would have specific legal implications. In practice, while the lessee usually initiates and pays for recording, the lease document itself requires the signatures of both the lessor and the lessee. The actual act of physically taking the document to the county recorder's office and paying the fee is what the question refers to as performed by, and this is most often done by the lessee or their representative. Question 385. To record a lease, there must be an acknowledgement of the document by the witnessed by an appropriate official. A. Lessee, B. Lessor, C. Notary, D. Realtor. Correct answer is B. Lessor. An acknowledgement is a formal declaration before a notary public or other authorized official by the person who executed the document, in this case, the lessor, that they freely and voluntarily signed it. This provides evidence of the genuineness of the signature and helps prevent fraud. The lease grants an interest in the real property, the right of possession, from the lessor, owner, to the lessee, tenant. For the lease to be recorded and provide constructive notice to subsequent purchasers or encumbrancers, the owner, lessor, must acknowledge that they are conveying this interest. The lessee signs the lease. Their acknowledgement is not typically required for the lease to be recorded. The recording primarily protects the lessee's interest granted by the lessor. A notary is the official who witnesses the acknowledgement, but they are not the party acknowledging the document. Realtors are agents involved in the transaction but are not parties to the lease agreement and therefore do not acknowledge it for recording purposes. Therefore, the lessor's acknowledgement, verified by a notary public, is necessary for a lease to be recorded and provide constructive notice under California law. Question 386. A real estate broker must retain copies of her listings, deposit records and receipts going back at least A. 1 year, B. 3 years, C. 5 years, D. The law doesn't specify years, just states records should be preserved for a good amount of time. Correct answer is B. 3 years. California real estate law requires brokers to keep copies of all listings, deposit records, receipts, and transaction documents. This retention period is a minimum of 3 years, starting from the transaction date or the listing's expiration. This requirement ensures that there is a sufficient record of the broker's activities for potential audits, investigations, or legal proceedings. While good business practice might suggest retaining records for even longer, the legal minimum in California is 3 years. Question 387. Regarding a land contract, during the period in which the vendee, purchaser, is still making installment payments and title has not yet been transferred, the vendor, owner, may A. Encumber the property with a mortgage after getting permission from the vendee, B. Encumber the property with a mortgage without getting permission from the vendee. C. May not encumber the property with a mortgage under any circumstances, D. None of the above. Correct answer is B. Encumber the property with a mortgage without getting permission from the vendee. In a land contract, also known as a contract for deed or installment land contract, the vendor retains legal title to the property until the vendee has made all or a substantial portion of the installment payments. The vendee holds equitable title and the right to possess and use the property. As the legal owner, the vendor technically has the right to encumber the property with a mortgage. However, this action is subject to the terms of the land contract and the vendor's obligations to the vendee. If a vendor mortgages property without the vendee's knowledge or consent, and this endangers the vendee's right to full title upon payment completion, e.g., through foreclosure, the vendor may be in breach of the land contract. This action can jeopardize the vendee's equitable interest in the property. The vendee could potentially sue the vendor for breach of contract and seek remedies such as specific performance, forcing the vendor to convey title, or damages. The specific terms of the land contract are crucial. Some land contracts may explicitly restrict the vendor's ability to encumber the property without the vendee's consent. It would be highly unethical and generally poor practice for a vendor to encumber the property with a significant mortgage during the term of a land contract without informing the vendee. Such actions could be seen as a breach of the implied covenant of good faith and fair dealing. While the vendor legally holds the right to mortgage the property, doing so without the vendee's consent can lead to severe legal repercussions. This is especially true if the mortgage puts the vendee's equitable interest and their future right to clear title at risk. Option B is technically correct in terms of the vendor's legal ownership rights. However, it's a risky action that could lead to a breach of contract if it negatively impacts the vendee's position. Option A is a much safer and more ethical approach for a vendor to take if they need to mortgage the property during a land contract. Option C is incorrect because the vendor retains legal title. Question 388. A landlord and lessee agree on terms of a 2-year lease for an apartment rental. The landlord signs the lease and sends it to the lessee, who receives it, moves into the apartment, sends the landlord 3 months' rents, but never sign the lease. Upon the completion of 3 months, the tenant decides to disregard the terms of the lease and move out. Given this scenario, a court will likely decide that A. The tenant is bound by the lease because he moved in and paid rent in advance. B. Since the tenant never signed the lease, he is not bound by it and can move out when he pleases. C. The tenant is bound by the lease because only a lessor, the landlord, need sign a lease. D. None of the above. Correct answer is A. The tenant is bound by the lease because he moved in and paid rent in advance. While the tenant didn't formally sign the written lease, their actions unequivocally demonstrate acceptance of its terms. Moving into the apartment and paying rent for 3 months are clear indicators that they agreed to the landlord's offer of a 2-year lease. This is known as acceptance by conduct or implied acceptance. The tenant's payment of rent and occupancy of the premises constitute partial performance of the lease agreement. Courts often recognize partial performance as sufficient to enforce a contract, even if it wasn't formally signed by all parties. Question 389. The term fiduciary does not apply to the following relationships between parties: A. Listing broker to seller. B. Truster to beneficiary. C. Attorney to client. D. Agent to principal. Correct answer is B. Truster to beneficiary. A fiduciary relationship is one where one party, the fiduciary, has a legal or ethical duty to act in the best interests of another party. This relationship involves trust, confidence, and good faith. Let's examine each option. A. Listing broker to seller. A listing broker acts as the agent of the seller and owes them fiduciary duties, including loyalty, obedience, disclosure, confidentiality, accounting, and reasonable care and diligence. C. Attorney to client. An attorney has a strict fiduciary duty to their client, acting in their best legal and financial interests. D. Agent to principal. The relationship between an agent and their principal is inherently fiduciary. The agent is authorized to act on behalf of the principal and must do so with the principal's best interests in mind. B. Truster to beneficiary. In a trust, the trustee has a fiduciary duty to the beneficiary, managing the trust assets in the beneficiary's best interest. The truster is the person who creates the trust and transfers assets into it. The relationship between the truster and the beneficiary is not typically described as a direct fiduciary relationship in the same way as the others listed. The truster establishes the terms of the trust, and once established, the fiduciary duty lies with the trustee. Therefore, the term fiduciary does not directly apply to the relationship between the truster and the beneficiary. The fiduciary duty exists between the trustee and the beneficiary. Question 390. The buyer's good faith deposit for the sale of 1 to 4 unit, owner-occupied residential property can be used for liquidated damages, but only if A. The total amount being forfeited is not more than 3% of the purchase price. B. The contract was recorded. C. The contract contains a liquidated damage provision in large type separately signed and initialed by both parties. D. Both A and C. Correct answer is D. Both A and C. Here's a breakdown of the requirements for using a buyer's good faith deposit as liquidated damages in the sale of a 1 to 4 unit, owner-occupied residential property in California. A. The total amount being forfeited is not more than 3% of the purchase price. California law generally presumes that a liquidated damages clause is reasonable if the amount forfeited is no more than 3% of the purchase price. Amounts exceeding 3% are presumed unreasonable and unenforceable unless proven otherwise. C. The contract contains a liquidated damage provision in large type separately signed and initialed by both parties. California law specifically requires that a liquidated damages provision in a residential purchase agreement be 1. Printed in at least 10-point bold type or in contrasting red print in at least 8-point bold type. 2. Separately signed or initialed by each party to the contract. Recording the contract is not a requirement for a liquidated damages clause to be enforceable.